Yeah, you're actually seeing me finish this book, tonight. Despite this holding, the court has been reluctant in recent rulings to presume. So yes, this is bullshit, though. They're saying that they have rejected the presumption that such a finding would inevitably result in religious incalculation, and I'm just like, it would, though. We can be sure of that. The court concluded that instead, as long as religiously inferiority grants prove not to be pervasively sectarian, that is, institutions in which the secular cannot be separated from the sectarian, the presumption of the state-sponsored religious indoctrination can be rejected. But the court also explained that a relevant factor in determining whether a particular statute on its face can be said to have had the improper effect of advancing religion is the determination of whether and to what extent the statute directs the government aid to pervasively secular institutions. Like, seriously, this is bullshit. Again, it's like the government, the people behind these cases want to hold everything to bullshit standards and say that it doesn't, this doesn't measure up unless it goes this far. But, the truth of the matter is that if the government, to any extent whatsoever, it violates, like, if there is even the faintest whisper of an effect, the most remote effect on it, then it is a violation, and these people should not be able to reject it. They should have their hands tied and be forced to rule the way that we want them to in this one. It, or be a criminal for ruling otherwise and go to prison and be locked up for doing so. Like, they should not have the choice to do otherwise or to hold it to any standard whatsoever. If it has the most remote effect, then it qualifies. The Bowen court also left open the possibility that, as applied challenge might reveal the constitutional deficiencies of the congressional funding statute if it could be shown that, in practice, the flow of aid reaches pervasively sectarian religious institutions, but these schools are that. This piece of the establishment holds that in some, the government may, as part of an otherwise religiously neutral program, directly sponsor religiously affiliated institutions with the aim of encouraging those institutions to provide education and counseling services to adolescents. But the Establishment Clause is breached when the sponsored institutions are pervasively sectarian. Applications of these tendencies to save a life's mandate reveal constitutional deficiencies, while the precedent holds that religious inspiration of affiliation with a religious institution does not by itself make the organization pervasively sectarian. Save a Life's evangelical imperative makes it impossible to imagine that a sectarian character of the organization is less than pervasive. Recall that the statement of faith, which states that all affiliates and volunteers are required to sign the statement, believe that all who receive by faith Lord Jesus Christ are born of the Holy Spirit and therefore become children of God, and that there is no other way to salvation, and believe that the Great Commission by which our Lord has given his church to evangelize the world, and that his evangelization is the great mission of the church. Signers thereby embrace their Christian duty to witness by the word and deed to these truths. Interviews with Save a Life directors also leave no doubt that Christianity guides all of the organization's activities. The directors attested to the central and indispensable role religion has in their organization and were forthright in revealing the defining characteristics of their organization is sharing the gospel. As one director summed up, our mission to share the gospel of the Lord Jesus Christ with women who are in crisis pregnancy, the services we offer. So this is an organization that is entirely religious and nothing other than religious. Since Save a Life is a persuasively sectarian institutions engaged in the practice of religious indoctrination mandated, Save a Life counseling impermissibly advances religion in contravention of the second prong of Lemon. Mandated counseling also breaches Lemon's third prong A precise definition of excessive entanglement is hard to come by in Supreme Court precedent, but considerations surrounding this prong typically attend to the tangible connections between church and state, such as administrative oversight of religious institutions and that accompanies funding programs. While the Save a Life mandate does not involve much in the way of its administrative oversight and interaction, this entanglement failure comes from the lack of government supervision and from what constitutionally required government supervision would entail. Given that evangelical Christian ministries provide the mandated counseling to ensure that religion is not advanced would require extensive and continual monitoring and direct oversight of every single counseling session. But such monitoring oversight would create excessive entanglement, thereby violating the First Amendment prohibitions. Instead, when grounds exist for assuming that a government-supported religious organizations are pervasively sectarian, as is the case with Save a Life, then more extensive monitoring would be required to protect against the risk of indoctrination. This, in turn, would foster excessive entanglement by virtue of necessary government intrusions into the operations of this religious organization. Failure under Lemon is by itself enough to show a violation of the Establishment Clause. But even while lingering as a primary gauge of permissible government violation involvement with religion, the Lemon test has been much derided, and conservative jurists have attempted to remove it from life support. Thereby, it is worth observing that the constitutional infirmity of the mandated Save a Life counseling is not tied to the fate of the Lemon test, the coercion test. In the Lee versus Wiseman test, the court ruled that an invocation and benediction by a clergy member at a public secondary school graduation ceremony violated the Establishment Clause. The court rested its finding on the principle that the government may not coerce anyone to support or participate in a religion, its exercise, or would otherwise act in a way which establishes a state, a religion, or religious faith, or tends to do so. In so holding, the court adopted the coercion test as an independent means for assessing Establishment Clause challenges. The coercive aspect of Save a Life counseling mandate is straightforward. The only way to construe mandated Save Life counseling as non-coercive is to suggest that minors have another option available to avoid participating in such counseling, namely consulting with their parents, but this is unconvincing. A minor who rejects Save Life counseling cannot be said to freely choose parental involvement. This is especially true when a minor seeks a bypass after her parents refuse to consent, or for that matter, if a minor is choosing involvement between involving her parents and receiving counseling. Rather, she is choosing between continuing an unwanted pregnancy and receiving counseling, but that choice is surely untenable. Under the Establishment Clause, this is problematic. While the coercive aspect of the mandated Save a Life counseling proves uncomplicated, this does not settle the outcome of the coercion test. It must also be shown that the coerced behavior constitutes participation in religious activity. Save a Life's counseling may not be a precise analog of public recitations of prayer that have been deemed unconstitutional in the court's recent application of the coercion test. Still, proselytizing by sharing the gospel, a practice employed by each of the Save a Life centers I visited, surely counts as religious activity. When a counselor asks a young woman about her relationship with Christ, or says that the only hope is a relationship with Jesus Christ, she engages in religious activity. Providing counseling based on evangelical explosion, for example, asking a woman, if you die tonight, will you go to heaven, is likewise a type of religious exercise. Showing women that the Bible or certain religious tracts as counselors, as Save a Life do, is comparable to leading someone in prayer. However, excessive entanglement by virtue of necessary government intrusions into the is comparable. However, the gospel is shared, whether through direct prayer or reciting of Bible verses or comments about the benefits of committing one's life to Christ. The evidence demonstrates that Save a Life counseling is a religious activity. Thus, when judges stipulate that minors obtain counseling from Save a Life, they effectively force young women to participate in religious activity, and in doing so, violate the Establishment Clause structures against coercion. It does not help minors that judges who require a pregnant minor to receive counseling from Save a Life do so in advance of determining whether that minor is sufficiently mature to proceed in an abortion absent parental consent. In doing so, the judicial policy of mandating counseling runs the following additional risk. The minor later deemed immature will have been required to receive religious counseling, while the government may not coerce anyone, whether mature or immature, adult or child, to support or participate in a religion or its exercise. The court has to respect particular apprehension when such coercion attempts affect those of an impressionable age. Endorsement test. The endorsement test derives from several concurring opinions authored by Justice O'Connor, and holds that direct government action endorsing religion or particular religious practices is invalid. This test does not preclude the government from acknowledging or taking account of religion. However, it does preclude the government from conveying or attempting to convey a message that religion or a particular religious belief is favored or preferred. Such an endorsement infringes upon the religious liberty of the non-adherent, for the power, prestige, and financial support of the government is placed behind a particular religious belief. The indirect coercive pressure upon religious minorities to conform to the prevailing officially approved religion is plain. A judge who requires counseling by evangelical Christian myths impermissibly endorses religion by sending a message to non-adherents that they are outsiders, not full members of the political community, and an accompanying message to adherents that they are insider, favorable members of the community. And though not a public communication, this message is arguably stronger because in the context of a coercive practice, indeed under the enforced participation in save-a-life counseling, as an audience gathered by the state power is lent to a religious cause. Secular pro-life counseling. The constitutional flaw of this counseling mandate opposed in Alabama arises from a pervasively sectarian character of Save a Life. Interestingly, however, it does not follow that a pro-life counseling mandate, a stipend of sectarian purpose and content, would produce a constitutional violation. A counseling mandate imposed by a judge who did not recommend a specific counseling program and imposed a state where minors could obtain pro-life counseling from a secular organization or even from a religious organization that is not pervasively sectarian would seem to survive constitutional scrutiny. Such a requirement would be free of the Establishment Clause infirmity. Moreover, constructed in this fashion, this requirement would be a mere incremental strengthening of informed consent mandates, which have already withstood cases on due burden test. To be sure, a non-sectarian pro-life counseling mandate would prove more burdensome than the informed consent mandates already in place, for the former would entail a person in in-person counseling session and thus add a delay. This hypothetical burden is not different from the kind or degree that is already allowed under KC. It shouldn't be. It's worth pointing out that virtually all crisis pregnancy centers, both in and beyond Alabama, are Christian ministries, so the prospect that a minor could obtain secular pro-life counseling at a crisis center is remote. Gaining access to bypass proceedings. Concerning the surveys of courts conducted in Alabama, Pennsylvania, the undue burden test asks whether the behavior of those designated to handle the bypass process amounts to the creation of a substantial obstacle in a minor's path. As we have seen, many courts are incapable of offering basic and accurate information about the bypass procedure in a timely fashion. The progress of a minor towards obtaining a judicial bypass hearing would obviously be impeded by the interaction with one of these courts. But the question of whether the state has created a substantial obstacle depends on the state's readiness as a whole to implement the bypass process. It's hard to deny that the magnitude of ignorance that we encountered in Alabama and Pennsylvania adds up to a substantial obstacle. Recall that in Pennsylvania, almost 3/4 of the courts proved woefully ignorant of their responsibilities, and in Alabama, 2/5 proved similarly ignorant. Even under my interpretation of Casey, whereby regulations are permitted unless they are likely to prevent a significant number of women from obtaining an abortion, Pennsylvania and Alabama would have seemed to have violated constitutional demands. The situation in Tennessee is another matter. While we come across considerable ignorance during our contact with the courts, we also found that in over 3/4 of Tennessee counties, a minor seeking to gain information on the way or route upon reaching a DCF advocate received adequate information. In all, we found only 14 counties where both courts and DCF advocates proved poorly informed about the bypass process. Whether this magnitude of ignorance amounts to a constitutional violation is unclear, especially given that the venue provision in the Tennessee permits minors to petition for a bypass in any county in the state. It is at least arguable that the degree of ignorance revealed in Tennessee, 15% of the state, is within the margins of acceptability under standing precedent. But we encountered more than just ignorance in Tennessee. Recall that in 13 Tennessee counties, it took between 5 and 17 calls to reach informed court personnel, and an average of nearly 5 calls to reach a DCF advocate who proved prepared to guide a minor through the process. and why we encountered instances in which the delay in obtaining information resulted not from the number of phone calls, but from personnel who proved unavailable, sometimes for many days on end. For a pregnant teen who seeks a waiver of parental involvement, the obstacle created by having to place numerous phone calls is genuine. Still, the precedent can be read as permitting the magnitude of administrative deficiencies that we found in Tennessee. Consider Hodgson versus Minnesota, where the court upheld the 48-hour waiting period that accompanied Minnesota's two-parent requirement. The court did so in the context of an as-applied challenge, despite lower court's findings that the regulation created sometimes noticeable delays and increased health risks. According to the lower court, the imposed waiting period is often transformed into delays of weeks or more between parental notice and termination of the pregnancy. This magnitude of delay, the lower court found, increased the medical risk associated with abortion to a substantially significant degree, conceding that the lower court's findings concerning the harm associated with the practical implementation of such a waiting period. The Supreme Court nonetheless concluded that the 48 waiting delay period, a minimal burden on the right to decide whether or not to inform her pregnancy. Yeah, well, you know what? This is a court being the worst. This is monstrous because it's like, screw them, we don't give a crap about whether it actually puts their life at greater risk to have this abortion as a result of this. We're gonna unless it literally dissuades her from doing it and dissuades a substantial number of them from doing it. It doesn't meet our standards of it. This is why court standards are often just the degree of scrutiny that they hold things to is often just ridiculous, and the bar is way too fucking high. In almost all cases, I have found that this is a profound frustration with the court when it comes to proving just about anything. It's like you have to prove it to a ridiculously high bar that shouldn't even be there in the first place. Although the district court found that scheduling factors, whether the minor's schoolwork and commitments, may combine in many cases to create a delay over a week or longer between the initiation of notification and the abortion, there is no evidence that the 48-hour period is itself unreasonable or longer than appropriate for adequate consultation between parent and child. Furthermore, both the district court's analysis in Hodgson and the Supreme Court's decision acknowledged some delays produced by judges who were unwilling to hear bypass cases, and both courts found that such delays unproblematic. See, that's the problem with the courts. Everything goes. Even though the district court ruled against Minnesota's consent requirement, he concluded that the bypass process as presently executed by Minnesota courts and other offices that participate in bypass proceedings complies with the procedural requirements set forth in 2 and approved in Planned Parenthood, Assans versus Ashcraft. This conclusion is remarkable, given that the court also found that despite the conscientious efforts to provide an expeditious court bypass option in non-metropolitan areas, a number of counties are not served by a judge who is willing to hear bypass petitions. A minor in one of these counties must travel to another county, most commonly a metropolitan county, to obtain an expeditious hearing of her petition. Although burdensome, this necessity does not reflect the systematic failure to provide a judicial bypass option in the most practical manner. Precedent thus suggests that a plausible case could be made that minors are only incidentally and not unduly burdened by the magnitude of delay associated with the administrative inefficiencies and judicial recusals seen in Tennessee. After all, it appears that delays of a week or more are permitted even when the state's own failures contribute to those delays. This is bullshit. This is holding things up to a standard that is ridiculous. That these things do not meet their standard of it means that their standard is ridiculous and that it's disqualifying tons of things that actually should meet it. The myth of Roe, and why Roe versus Wade has attained an iconic status in political and cultural discourse of this country. There's a new sheriff in town, and his name is Casey. With Roe's displacement, the states may well find constitutional support requiring fetal representation to persuade young women to carry their pregnancies to term. Pro-life counseling of the non-religious reality may also find constitutional sustenance, and why widespread ignorance of the bypass option is constitutionally indefensible. Casey may well tolerate involvement mandates wherein minors face the prospect of maneuvering through a maze of bureaucracy. Casey's permissiveness comes from its failure to intelligently distinguish between encouraging childbirth and hindering abortion. This unintelligibly empowers states under the guise of advocating child support to place significant barriers in the path of abortion, precisely what the ruling permits to forbid. Casey invites states to devise, for the sake of the fetus, whatever obstacle course they wish women to maneuver through, as long as the obstacles, however high and onerous, are capable of being hurdled and do not impose serious health or safety standards. And my frustration here is that they do actually provide serious health or safety standard hazards. The Casey's case may be providing sanction to such obstacles does not mean states should accept the invitation to craft bad public policy, but states and judges have accepted this invitation, imposing regulations that advance a particular moral view of personhood, pregnancy, childbirth, and abortion, because Casey permits states to increase the price tag for abortion and inflict mounting delays under the auspice of so-called incidental burdens. Minors may be made to bear the weight of the state's moral perspective. Young women are not the only targets of such added burdens. Several states have fortified informed consent provisions that all women seeking an abortion, some have done so by way of requiring in-person counseling of phone, or instead of phone counseling. Others, like Ohio, now require that the treating physician, rather than a nurse practitioner or physician's assistant, communicate state-mandated information on abortion. Additional steps to augment the informed consent provisions are in the works. Michigan has enacted a provision requiring a doctor who has taken an ultrasound of the fetus to offer the woman the option of viewing the image before an abortion. Following this lead, the Georgia State Senate legislation will require all women seeking an abortion to be offered the opportunity to view an ultrasound or sonogram of the fetus. In light of these ongoing efforts, we should be surprised to see that state legislators pursue statutes to codify the judicial practices we have seen minors face in the bypass process and extend them to adult women. For example, under Casey, and given the current political environment, legislation requiring all women to obtain pro-life counseling or to meet with designated representative of the fetus prior to obtaining an abortion may well be forthcoming. While these measures would better serve the goal of ensuring women that a choice contemplates the consequences for the fetus. But requiring adult women to discuss her abortion decision with a pro-life counselor or guardian who seeks for the fetus is a chilling prospect, one that should be seen as striking at the heart of liberty. As John Paul Stevens rightly notes, serious questions arise when a state attempts to persuade a woman to choose childbirth over abortion. Decisional autonomy must limit the state's power to inject into a woman's most personal deliberations its own views of what is best. The state may promote its preferences by funding childbirth, by creating and mandating alternatives to abortion, and by espousing the virtues of family, but it must respect the individual freedom to make such judgments. I'm really kind of pissed off about all this because, again, just because you work in the government doesn't mean that your personal preferences are actually the interest of the state. This is a messed up way of looking at things. The popular American conscientiousness is replete with pious-sounding myths: the separation of church and state, freedom of state, one man, one vote, separate is not equal. Among these platitudes is Rose, so familiar its rock star status that goes by one name, like Madonna and Prince. But as the case with these other ubiquitous aphorisms, what lies behind Roe is far less substantial than what is imagined. The fact is, whatever Roe may once have been, it is no longer, and whatever confidence may have instilled is no longer justified. Casey is a much different beast whose wrath has not been fully filtered or digested by the popular imagination. Myth-guided policy, the law is real, but it's also a figment of our imagination. The argument of this book is directed at those who have made a good faith compromise on parental involvement issue. These compromisers, a group to which I once belonged, have in mind a picture of what a world with such mandates will be like. Pregnant minors will be encouraged to seek guidance from parents, and courts will protect those who choose otherwise. We have seen, though, that many courts are not prepared to do their duty, whether due to ignorance, recalcitrance, or incompetence. We have seen judges who are willing to employ hardball tactics to get minors to bend to their will. Whatever the Supreme Court may decide about how much implementation and failure or is too much, or what obstacles too burdensome, it is up to the good faith compromiser to decide whether the realities of parental involvement mandates sufficiently approximate her picture to warrant continued support. This is a personal decision. To my mind, the case is clear. I invite the reader to be her own judge. The scope of the bypass irregularities. Evidence suggests that the types and implementations of failures we have seen in Alabama, Pennsylvania, and Tennessee are not unique to those states. For example, Melissa Jakey's study of Texas conducted in 2003 found that only 108 of the 254 county courts were prepared to handle the judicial bypass product procedures of the state's parental notification law. Jacobs found that the unprepared courts were commonly confused about the court's duty to appoint an attorney. A large number said that the minor would either need to obtain an attorney on her own or represent herself. Some explained that the minor would not need an attorney. A significant number of clerks expressly stated that the judges would not appoint an attorney would not have the time to appoint one. Jane's Due Process, of which, because of this book, I became a donor, a nonprofit advocacy group that helps Texas teens navigate the bypass roads, reports that minors sometimes confront resistance from judges who follow their personal predilections in handling waivers requests. One minor reportedly gave the following account of her hearing. The judge started crying. He left the room. When he came back, he said that I reminded him of his granddaughter and that he wouldn't sign the order because it was a life or death situation. It wasn't a life or death situation. Another said of her effort to obtain a hearing in Texas. I went to the courthouse to file my application for judicial bypass, and the judge came out of his office and told me that he would give me a hearing, but he didn't believe in abortion, that he would never give me the okay to have one. In North Carolina, the Roanoke Times reports court clerks in one county, in blatant disregard of confidentiality requirements, called the parents of a pregnant teen who sought a petition to waive parental involvement. Maybe the most widespread and longstanding display of resistance to involvement mandates comes in the form of judicial refusal to hear bypass petitions. Several accounts suggest that the judges in Indiana, Massachusetts, Minnesota, and South Carolina have opted out of bypass hearings. A 1992 newspaper article reports that minors looking to waive parental involvement in Indiana are often advised to go out of state, in part because judges refuse to hold hearings. Recusals in Massachusetts date back as early as the 1980s. According to a 1983 article, 8 out of 62 Massachusetts judges authorized to hear bypass hearings were unwilling to do so, claiming that they have moral problems with abortion, and another 2 were unwilling to hear petitions filed by minors who are more than 12 weeks pregnant. Despite the reports that Massachusetts has one of the smoothest functioning bypass systems, the recusal trend continued. As a 1992 New York Times story indicates, some minors must travel long distances because the judges in their areas will not schedule abortion hearings. So, this is insane. Jamie Sabino, an attorney who has helped organize lawyers to represent minors at hearings, has said of this Massachusetts recusal, there is only one. This is the only area of law where judges recuse themselves just because they don't want to hear a certain kind of case. They don't say, I won't hear that case because I don't believe in capital punishment, but somehow in this country, abortion is outside of regular rules. Minnesota has also seen its share of recusals. Patrice O'Donovan's 1983 analysis of the bypass process states that judicial recusal is especially acute in Minnesota, where very few judges, aside from the 3 juvenile court judges in Minneapolis, St. Paul, and Duluth, have assumed their responsibility to implement the law. A similar pattern is evidenced in the findings, in fact, delivered by the U.S. District Judge Donald Aesop in Hodgson versus Minnesota. Reviewing the bypass process from 1981 to 1986, Aesop found several Minnesota counties where judges refused to preside over bypass cases. In South Carolina, the consequences of recusals are eliminated by a story told by Billy Lomenick, a woman who helped her grandson's girlfriend, Mary, secure an abortion out of state. In a statement before the U.S. House Judiciary Committee, Lomenick explained that her failed attempts to find a South Carolina court who would hear her bypass decision. Mary was in an abusive home, Lomenick reported, so I called around the state to get her abortion, and no judge would hear me. Lomenick explained after more phone calls, we were only able to find 2 courts in our whole state that would take the judicial bypass cases. The closest judge who would hear a petition was over an hour from our home. Our hopes were dashed, however. We learned that the judges had announced only a month earlier that the courts would take cases from minors residing within that county. In the end, Lomenick arranged for a bypass hearing in Georgia, 3 hours from their home in South Carolina. Because bypass hearings are closed and court records sealed, it is difficult to determine the scope of pro-life judicial activism. In this context, authoritative information about bypass cases is sometimes available from appellate rulings, but not all states publish such rulings. Not all such rulings are revelatory of judicial practice, and presumably not all minors who are denied a bypass's appeal. Moreover, extremely well hidden are those problematic judicial practices that occur in the context of hearings that result in bypass grants. As one lawyer who routinely represents minors in bypass cases in Massachusetts said, the vast majority of justices handle these cases, these hearings, with some dignity and some compassion, but we tell people to avoid 25% of the judges. Laws are generally implemented through appeals. The judges know that as long as they grant a minor's petition, there is nothing to appeal, and therefore no one will look at how they conducted the hearing. Nevertheless, others have reported judicial antics similar to what I have described. The judicial practice of appointing guardians to represent the unborn has taken hold in Montgomery County, Alabama. It was not invented there. In 1998, a Florida judge appointed a guardian to represent the fetus at a bypass hearing. Though the judge found in the minor's favor, the guardian went on to appeal the ruling to the Florida Supreme Court, at which time the High Court rejected the appointment. A judge in Louisiana faced a similar rejection upon appointing a fetal representation in 1991. And an article in The Nation indicates that a judge in Indiana was also overruled after appointing fetal representation. Unlike in Alabama, trial judges in Florida, Louisiana, and Indiana have been rebuffed when appointing guardians for the fetus, but the rationales put forward in at least two of these reversals do not close the door to future guardianship appointments. In Florida, the High Court was notably brief when it came to its rejection of the appointment, saying only that the preliminary, we find that the appointment of a guardian ad litem for the fetus was clearly improper. And that's really all that it says. In Louisiana, the state Supreme Court granted a motion to revoke the lower court's appointee of an attorney, stating that it's simply the state's parental consent statute does not contemplate the appointment of an attorney for the fetus or for an adversarial proceeding. In neither instances did the high courts reject appointments on federal or constitutional grounds, nor did the courts consider or provide arguments or referrals that to precedent to bolster the holdings. Additionally, the mere fact that such appointments have been tried suggests a judicial disposition towards creativity when it comes to discouraging abortion. At the very least, the door to guardianship appointment remains open for other states to test. The report indicates that judges in Texas may be doing so. The survey of the Texas courts conducted by Jacobs revealed that 2 courts stated a guardian ad litem would be appointed for the fetus in bypass cases. Relatedly, there may be some backdoor avenue for giving voice to the fetal interest in the courtroom. Some guardians appointed to the minor in the cases have been reported as saying that instead of representing the interest of the minor, they represent the fetus. Additionally, The Nation reports that Judge James Payne in Indianapolis, for example, routinely appointed anti-abortion lawyers to represent pregnant girls. Like the guardianship appointments, the judicial practice of mandating pro-life counseling has appeared outside of Alabama, and according to The Nation, judges in Mississippi require visits to anti-abortion counseling center before hearing. Linda Lazinski, an Ohio social worker whose jobs included interviewing juveniles prior to their hearings, says in a 2006 account of the functioning bypass process, in our juvenile court, I have observed a number of judges who fall into several categories. Each is guided by personal beliefs, not about maturity, but about abortion. One type of judge believes that agencies we rely on for pregnancy counseling don't give proper emphasis to a pro-life viewpoint, and so provides a separate list to the Jane Does. Judges in that category require them to visit one of these places and bring back some literature as proof, then quiz the young woman on their errant sexual behavior. Leading support to the practice of requiring pro-life judges or even religious counseling as part of the bypass process is Judge Priscilla Owen, formerly of the Texas Supreme Court and now on the bench of the U.S. Court of Appeals for the Fifth Circuit. A controversial Bush appointment to the federal courts and on some people's short list for a slot to the Supreme Court. Owen earned some renown for her opinions in bypass appeals. In the Texas Supreme Court first ruling on the parental notification statute, Owens wrote the concurring opinion expressing support for more stringent counseling requirement. The court properly requires a minor to consult a healthcare provider about the general risk of abortion, but that is insufficient. I would require a minor to demonstrate that she has sought and maintained meaningful counseling from qualified source about the emotional and psychological impact that she may experience now and later in her life as a result of having an abortion, but she should be able to demonstrate to the court that she understands that some women have experienced severe remorse and regret. She should also indicate that to the court that she is aware of, considered that there are philosophical, social, moral, and religious arguments that can be, yeah, there are some women who have, but they don't necessarily represent, anybody more than themselves. I mean, this is just, the court cannot, of course, require a minor to adopt or adhere to any particular philosophy or profess any religious belief, and requiring the minor to exhibit awareness that there are issues, including religious ones, surrounding the abortion decision that is not prohibited by the Establishment Clause. Despite the apparent problems with the bypass process, the minor who finds her way to a bypass hearing has had a very good chance of getting her petition granted. For example, of the 3,573 bypass petitions filed in Minnesota between 1981 and 1996, some 3,558 were granted. A study of 477 bypass cases heard in Massachusetts between December 1981 and 1985 revealed it's only a single bypass denial, and a 2003 survey of Ohio's largest juvenile court shows that 9 times out of 10 a judge approves a teen's request to have an abortion without notifying her parent. My own study confirms that Pennsylvania judges who hear bypass petitions rarely deny them. Some supporters of involvement mandates have seized on the high rates of bypass grants to suggest the process is slanted in favor of the minor. For example, Mary Spalding Balch, who monitors the state legislation for the National Right to Life Committee, said it suggests that the judicial bypasses amount to little more than a rubber stamp, and it's like, what would be the problem with that? Similarly, you say that like it's a bad thing. Similarly, according to the Pennsylvania lawyer and pro-life activist Joseph Stanton, the petition is boilerplate, and the hearing has all the earmarks of a rubber stamp. The high approval rate of bypass petitions does not provide grounds for concluding that the process is functional or lacking in problematic consequences. Firstly, it's likely that the high success rate owes in part to the character of those minors who choose to pursue this route and succeed in finding their way to the hearings. Older and more mature minors tend to avail themselves of the bypass option. Furthermore, both judges and lawyers who handle bypass cases often comment that the very fact that the minor has the facility to overcome the hurdles on her way to the courthouse in search of a waiver provides some evidence of maturity. A high rate of success, therefore, may tell us that minors who choose the bypass option then about the functionality of that option. As the Minnesota judge testified, what I have come to believe is that the really judicial function is merely a rubber stamp. This decision has already been made before they have even gotten into my chamber. The young women I have seen have been very mature and capable of giving the required consent. Second, a minor may ultimately make her way to the hearing before a judge who is likely to grant her request says nothing of the effort she makes to get there. Indeed, the high rate of bypass grants owes in part to form shopping. Abortion providers and court personnel often advise minors to avoid certain judges and seek relief from others. The same survey of Ohio noted that indicates that when judges show a disposition to deny bypass petition, abortion providers steer girls to another county, already knowing what the answer will be. Cincinnati, located in Hamilton County, provides a case in point. Few teens even ask for permission in conservative Hamilton County, the birthplace of the right to life, reports Phil Trexler of the Outcome Beater. Despite the state's third largest county, the number of requests to the Cincinnati judges compares more closely to the smaller rural counties, with only 2 bypass requests were filed between 2001, and 2003. Teens are routinely referred to courts outside the abortion debate inferno in Hamilton County. They travel far from Cincinnati because of the long history of denials and subsequent appeals. Although contributing to the high rate of bypass grants is the fact that with many conservative judges refusing to handle bypass requests, the judges willing to hear these petitions often have liberal inclinations. There's every reason to believe that these judges, like their conservative counterparts, approach hearings with a political lens that, unlike their counterparts, are predisposed towards granting bypass petitions. Take, for instance, an admittedly pro-choice judge who offered the following frank comments about his own liberal outlook when asked to compare himself to the pro-life judge. All of us who come to the bench with biases, the trick is to contain those biases and try to do what you think is right under the law. My own philosophical view causes me to act the way I act in these cases. I don't know that I put my views aside. I'm guilty of that. I don't know that I put my views aside. I'm guilty of that. I do it in the way that I think is right. I'm in the position to advance my views, and I'll do that, but I'll follow the law. Where the threshold for where's the threshold for maturity? My threshold may be a lot lower than a pro-life judge. I meet these women, I'm impressed with them, I'm satisfied. I don't rubber stamp it. I'm genuinely interested in these women, and for me, if we have an intelligent, rational conversation, I'll find them to be mature. The judge also expressed the view that is repeated by many who handle the bypass cases. I'm not sure if she's mature enough to have the abortion, whether she's mature enough to go through with the pregnancy. If she's not mature enough to have the abortion, whether she'd be mature enough to go through with the pregnancy. Legal scholar James B. Raskin elaborates this paradox in a similar fashion. How can a girl who's too immature to decide whether to have a baby, how can a young girl be too immature to decide whether to have a baby, but mature enough to go through with the pregnancy, give birth, and make 1,000 important decisions regarding how to nurture, raise, and educate the child or the children in cases of twins or other multiples. It would never be in the best interest of such an immature person seeking an abortion to be denied one and instead forced to go through the complicated physical, emotional, and personal changes imposed by pregnancy, childbirth, and motherhood. This perspective may lead judges to conclude that when a minor fails to prove the maturity prong of the longest standard she has, in doing so, that it shows that a bypass is in order by proving that the abortion would serve her best interest. Thus, supporters of the involvement mandate are correct to absorb that judges are regularly approve bypass petitions, and this is in part indicative of a liberal bias, but these points do not offset or redress the problems associated with getting to a hearing in the first place, nor do they advance the case that parental involvement mandates, at least if one accepts the compromise view that blanket mandates are unacceptable. Rather, they provide additional evidence of the political manner in which these petitions are handled and the lack of congruity between how we hope the bypass process will achieve, what we hope the bypass process will achieve, and what it in practice achieves is. If the parental involvement compromiser has too rosy a conception of how the bypass process will work in the world, what accounts for this? Presumably not a failure to recognize that pro-life advocates generally serve as champions of parental involvement and aim to prevent abortion through such legislation. In fact, pro-life advocates do not shy away from professing their primary aim in sponsoring involvement in legislations not to secure parental rights, but to end abortion. In fact, for example, on Sunday, June 5th, 2005, Texas Governor Rick Perry signed legislation mandating parental consent for abortion, replacing a notification bill that had been in place since 1999. Step in the wrong direction. Though not a surprising move, what was surprising, or at least extraordinary, was the bill signing ceremony. In a gesture boldly signaling the political and religious character of the abortion battle, Perry took the ceremonial signing event to the school gymnasium of an evangelical church. The governor's remark to about 100 were predicated by speeches by several pastors, followed by a closing benediction. And an Associated Press writer, Matt Curdy, described the occasion as even for Texas. The scene was remarkable. The governor, flanked by out-of-state televangelists and religious right leaders, signing legislations in a school gymnasium amid shouts of "Amen" from Baxter's, could as well have been attending a revival. Governor Perry gave a superficial nod to the interest of the pregnant teens, saying, "A nurturing home with a loving mother and father is the best way to guide our children down the proper path." But unlike his decision to sign the bill at a school church, with the words of his speech revealed the primary impetus behind behind the legislation. "We may be on the grounds of a Christian church, but we all believe in standing up for the unborn," Perry preached. "For too long, a blind eye has been turned to the right of our most vulnerable human beings, and that's the born in our society." Despite the transparent link between the pro-life movement and parental involvement mandates, many abortion rights supporters have been willing to bargain with pro-life opponents because the bypass option is available, carries the weight of the law, and bears the constitutional imprimatur of the Supreme Court. Maybe as important, the bypass safety valve is placed in the hands of the judiciary, an institution thought to be capable of withstanding the muck of politics and the red tape of bureaucracies. But the judiciary is not so capable. What, for instance, of the judges classifies the bypass proceedings as a capital case, since it involves the question of whether the minor's unborn child should live or die, and who rules against the minor on grounds that it is not an act of maturity on her part to push the button of death of this child upon the conscience of the court? And what of the telephone that rings unanswered at the Tennessee Department of Children's Services? Many abortion rights supporters have not anticipated such possibilities and instead have fallen victim to the myth of rights, an ideology that fosters a naive faith in the impartiality and functionality of the judiciary. The myth of rights. In the politics of rights, Stuart Wright appeals to the symbolic life. To understand the political importance of American law, Steingo insists it is not enough to consider concrete manifestations of legal institutions or to take into account the immediate reactions or to compliance with legal rulings. These are important matters to be sure, but they should be understood in connection with the patterns of belief evoked by legal symbols. In its symbolic form, the law shapes the context in which American politics is conducted. Alerting us to the law's symbolic life and power, Sango departs from the conventional view that law and politics are distinct realms. Although not neither the first nor the last to argue for a political analysis of law and rights, nor alone in focusing on the symbolic and ideological character of law, Sango offers a unique and compelling depiction of the law's hold on the popular imagination in America. Like all fundamental social institution, law casts a shadow of popular belief that may ultimately be more significant, although more difficult to comprehend, than the authorities, rules, and penalties that we ordinarily associate with the law. What we believe reflects our values. It also colors our perception. What we believe about the law is directly related to the legitimacy of our political institutions. Sean goes is the popular belief about the law, the myth of rights. The myth of rights is an ideology that rests faith on the political FSG and ethical sufficiency of law as a principle of government, in contrast with the distrusted branches of government. The